Okay, good afternoon to my listeners. Today we will start with the new topic, that is concept of human rights. Basically, human rights को हिंदी में मानव अधिकार भी बोला जाता है. So they are the two words, human and rights. When we talk about the rights, right belongs to the living things. Uh, in living things, there are two types: human kingdom and the animal kingdoms. And man is a social animals who have been the high reasonable quality of mind. So we provide rights to the human being. But it does not mean animals do not have any rights. They have also rights, but they are not recognized in our world. So we recognize the human being from birth to the death. So what it means? It means the rights is belongs from to the persons irrespective of any sex, caste, color, religion, etc. So this rights is given to the human being from birth till death. When a person is born as a child, so first right is mother milk. Up to 6 months, it is a birthright of a person to get mother milk from his or her mother. Afterwards, when he moves into a school, then right to education, and later on, this right has been growing till the person goes into a tomb, or you can say burial place is there. Till after that also some rights has been available to the dead body, just like a we cannot defame the person who is not in existence in our world. If we are trying to defame somebody, then it is a punishable under 499 of Indian Penal Code 1860, either written form or oral form. So this four words had been inserted with a human being: right to life, liberty, equality, dignity. So, and everybody is treated irrespective of different culture, religions, etc. So, today this word human right has been coined by the UNO after the Second World War. The UNO has been formed on 24 October 1945, where he includes rights of a man and woman. So let's we start with the rights. Why? Because in a second after Second World War, the rights has been given to the females. So it means man is in this society dominated by the male. So the rights has been from ancient to more till Second World War is belongs to the male. So basically, this word human right, it includes at international level, there are the three generation of human rights. Number one, civil and political rights. Number two, economic, social and cultural rights. Number three, uh, the rights does not belong to first and second survival rights. So if you talk about the civil and political rights, so basically, if you look at the origin of human rights, or you can say natural right, it has the roots into a different phase of the world. In the first time, it has been introduced by the Babylon city, ruled by the Lord Hammurabi, and he speak about the Hammurabi codes, where right to life, property, trial has been included, and it is a necessary for a human being for the part of natural justice. Later on, if we move to the Western, in a Western, basically in ancient period, two civilization is moving out, Greek civilizations and the Roman Empire. Basically, Greek civilization belongs to the natural part. They believe in a nature, so they compare the right as a justice, as a virtue, and from this, man is a social animal. He lives in a nature. Nature is commanded, so his duty is towards the nature, and from this right has been there, natural right has been there, and this religious rights has been come out in a this Greek theory. But the Romans, they are differ from the Greeks. Romans talk about three factors: time, place, conditions. And they say this human right is these rights are evolving from one generation to another, and it has been differed from one place to another, and it should not be confined into a particular place or particular area. It has to be spread, and it is a everlasting. It is changed from one generation to another generation. So they criticize to the Roman Empire. Then we come in a medieval period in the Western thought. We talk about the 12th or 13th century. The profounder is the Saint Ambrose. Basically, it was overrated by Western culture. They believe in a religions, God. They say God is the factor, and this Christianity, Pope, and the other religious leader, they are the representatives. So church system has been there. So basically, they talk about that human being is nothing. It has to be guided by the religious and given by the religious leaders, guided and overall guided by the God. So afterwards, in a Western till 15th, 16th century, some natural thinkers has been there, natural lecture thinkers who has given the fundamental rights, you can say, or the natural rights, or the basic right, or inalienable rights, which cannot be taken from human being. So the propounder is Thomas Hobbes, John Locke, Jean-Jacques Rousseau. Basically, they are the propounder of social contract theory. So Hobbes has seen the war between the England and the other country. So imagine in a war is there, and war has been there, and everywhere persons cry, they are just hold their hand for their life. So nobody is there to support them. So he take the example of a uh, society. See, some society will come out and they will protect the right. So if we compare today, he talk about the government. Basically, for a state, four element is necessary: government, people, territory, or sovereignty. So government also three parties there: executive, legislature, judiciary. Now fourth pillar, that is democracy, press is also included, but not officially. So he talks about the government in today's scenario who will protect for the people, by the people, to the people. And it is the duty of a government to provide fundamental right to their citizens or the persons who came from other country. They also get some rights in our country. His view has been criticized by the John Locke. He says individual right is the prime importance, and society is built from the people. So people have the natural right over the society. It includes right to life, liberty, security, property, etc. So, and his view has been we taught today in our Indian Constitution in Part 3, that is called as fundamental rights, which is essential for for a human being who lives in this country. So basically, there are 6 fundamental rights in our Indian Constitution which is given to the citizens. That is right to equality, right to freedom, life and liberty, exploitation from rights, freedom of religions, cultural and education right, and the last is right to constitutional remedy, Article 32. If any state or authority or somebody is trying to violate, then every person has the right to file under Article 32 of the Indian Constitution for the violation of fundamental right to the Supreme Court, the apex court of our country, for the violation of fundamental. There are the 5 types of writs is there for protecting our right: right to habeas corpus, provisions, quo warranto, certiorari, and the mandamus. These are the 5 types of writs has been there. So has been used in a exceptional circumstances for their constitutional rights, and under legal right include fundamental rights. So afterwards, Jean-Jacques Rousseau basically is a French thinker. His idea has created the revolution, did the birth of French Revolution 1789. He has given the theory of will. He says we talk about the sovereignty, where government and the people's will has been there. So if you look at today's scenario, sovereignty is the prime importance. We elect our representatives who work for us. So he believes in a democracy, and for protection of a fundamental right, we need democracy where all the rights are on equal pedestal. No discrimination should be made by the state on the basis of religion, caste, color, creed, etc. But on the basis of intelligence and the classifications, this employment factor can be differentiated, but it should not be discriminated by the state on this general ground. So afterwards, then Immanuel Kant, he has given the metaphysical theory. He talks about the independence of rights. He says man is a supreme. He is not a slave to anybody. So what he means, he says he does not want to be killed, or he doesn't. So other person will not kill, or he did not injure, so other person will not injure him. So when we talk about the rights, if there is a right, there is a duty. If duty, then right. So right and duty are the correlative to each other. If I have a right to enjoy my privacy in the night, so other person who lives in a nearby have the duty not to disturb my peace. If he is trying to do, I have the right to call a cops 100 and tell this person is disturbing my privacy. So this right and duty concept has been there, and it is existing. So for this Immanuel Kant, independence has been there, and freedom of dignity is a prime importance. Dignity is an important factor, and nobody has the right to disturb their dignity. And his idea lead to the abolition of slavery in the world. Slavery convention has been passed around mid of the 19th century. Then these are the thinkers who are the first generation of in human rights that talk about the civil liberty. Then, when we talk about the human rights, we talk about the second generation of human rights also. That is economic, social, political, and cultural rights. In this, और we can say ये राष्ट्र की स्टेट की जिम्मेदारी है कि सिविल और पॉलिटिकल राइट के बाद स्टेट आपका क्या कहते हैं सिटीजन जो इंसान है उन्हें रोटी कपड़ा मकान और जो भी अदर ज़रूरत की चीज़ें हैं जैसे एम्प्लॉयमेंट फैक्टर लीगल एड एनवायरनमेंट एजुकेशन एटसेट्रा वो प्रोवाइड करे पर्सन को अपना आप को रूम करने के लिए फॉर दिस in internationally, the founder of this story is a Karl Marx. Basically, he had written the book Das Kapital. He says there should not be difference between the have and have nots. Basically, in a society, two classes are there: have and have nots. Have means the person who have all the things. Have not means who does not have single. So there is a always clash is there between have and have not. So have will use have not in the form of a labor as a product, use it, then fire it. So he talks about that if a labor class has been used it and we are providing to the labor class some amount, then his right will also be protected in the form of industrial laws. So his view has given rise to the industrial and the social law, just like a Factory Act, Industrial Dispute Act 1947, Trade Union Act, Maternity Benefit Act 1961, where the female worker is there if she is pregnant or unfortunately his or her miscarriage has been there at the working place, so she will get some compensation. So his views have taken the second generation of rights, and ultimately in our country also in Indian Constitution we talked in a part 4 बाद 4 में हम बात करते हैं directive principle of state policy which is given to the citizen in direct form of right. It cannot be exercised directly, but it can be exercised indirectly in the form of PILs relating to the environment, child labor, etc. So, this third generation has been there. Then other thinkers has been come out in the 20th century, just like John Rawls, theory of the justice. Justice has been provided to the persons. Then Daving, Stamler, they are the revival of the natural law thinkers, and it rose to the this one major development in the world. First World War, League of Nations has been established from 1919 to the up to 1939, 20 years. League of Nations has done the work, but some discrepancy is there. From 1939 to 1945, Second World War has been there, where the large number of mass killing has been there. So 5 countries who has been now a member of permanent member of Security Council, they think that some organization has to be made which trying to maintain international peace and security all over the world, and they given the name that is called present United Nations. At present, 195 countries there, the member of a United Nations. They have the 6 organs who just maintain the work of a UNO and protecting the right. Number, if a some new country has to be admitted, or the succession part, that part, or expelled, or take the necessary steps. General Assembly is there. Number two, Security Council for maintaining the international peace and security. Number third, for this second generation, Economic and Social Council. Number four, Trustship Council, the countries who do not have, who just in a colony or somebody, or who live independently. So this one is there. Then ICJ, International Court of Justice, where the case has been come out for the national or the country, between two country or more than two country, and the matter goes to the ICJ. At last, Secretariat, it has been headed by the Secretary General of the United Nations, who will look after the meetings and this. So this I say in this UNO is trying to protect the human rights at the international level or the national level. Law of the land, the laws has been there. So this we have taken the Western thought. Now we come to our Indian thought. In Indian thought also, this we have the right, or we just say in Hindi adhikar, and we just get from the just claim, and it should be based on the status, things, place. If you look at the ancient scenario, it is based on your powerful, who having the so much sword, they can take it and conquer the other territories and under. But still, we talk about the divine theory, and divine theory comes under the domain of a dharma or the dharam, and it is the duty of the king to protect their subject, or you can say public. So dharma has a fourth pillar: ahimsa, brahmacharya, dama, or it means zero tolerance, without violence. Dama means control over physical organs as well as mental organs. So these are the four pillars, and it is the duty of a king to obey it and to follow it. And what is the role of a king? If we talk about in a Gita or the other, so Praja Palan, just like a father, he has to protect their subject, being a head of family. Praja Rasak, he has to protect his subject from internal and external. Praja Ranjan means economic, political, social development has to be there. Pilgrims. So if you look at the Nalanda in a historical background, so many pilgrims or the university is there for the overall development of a person. And fourth is act as a judge, means impartial and the fearless has to be there. No partiality has to be there. So this concept in our ancient has goes up to the medieval period also. In Quran also, some no doubt human rights has been violated in the time of Aurangzeb. Mostly human rights violation has been there. The forcefully Hindu has been converted into a Muslim. But some of the person is there before the Aurangzeb who's trying to protect the rights of a man, just like a Jahangir. We study in a story, he just make a ghanti. If anybody having some problem, they will just ring the rope, and the king will appear and ask what is the problem. It has to be sorted out. But still, for protection of the rights, some of our Hindu religious leaders or the persons has been written it, and they just trying to protect it. And some of the fierce fighter leader have been come out against just like Maharana Pratap before Akbar, or Shivaji, or Bruce Robinson, they just came for the protest. Bruce Robinson came for the protection of the rights of a Kashmiri Pandit. So at that time, this peer leader has been there who trying to protect the rights of a common man. Later on, when Britishers has been there, no doubt Britishers has created atrocity, but still some of the right they are trying to made it just like a religious leader, Ishwavidya Sagar, Ram Mohan Rai, this Sati Pratha and the other practice has been removed, and many more of the leader has been come out to protect the rights of a child or the females. Later on, industrial laws has been made for protecting the rights of a worker. Then the most important factor has been come out, that is the in a criminal law system, three major law has been come out. First of all is the in 1860 Indian Penal Code has been come out. Before this, no doubt, punishment factor has been there, but how the victim will get a justice, how the offender will going to be punished, and what offense he has committed. So Indian Penal Code has been there, where the offense and the punishment factor has been there. And in 1898, Code of Criminal Procedure has been come out, how the offender will get the punishment from trial process, from FIR to the judgment. Different procedural law aspects has been there, and how person will go to punish, what are the evidences. Everything should not be in orally, something be in written. So Indian Evidence Act 1872 has been pictured for there. Later on, before constitutions, this our leaders has trying to draft a constitution which has been made from 1946 to 1949. Different hundreds of times of the rights has been changed. This Constituent Assembly debates has made the recommendations. At last, on 26th November 1949, our Indian Constitution has been adopted, and 26th January 1950, it has been came into a force, and it has been open to the public 26th January. At why we need 26th January is also the history. In a 1930, Bharat Gandhar Tilak, he says, Swaraj is full my right. It means complete independence from internal or external factor. That is why we opt 26th January 1950, where India is a complete independent. It should not be controlled by any other body, just like a Britishers who have ruled our country more than 300 years. And this constitution has been adopted, and it has been covered, and where till present in Indian Constitution 395 articles has been there. So it talks about the legislature, judiciary, executives, then center-state relations, and if we require amendment of the constitutions has been there, time and it has been there. So this has been the general concept of a human right, where we complete of the first generation in the international second generation, third generation of human rights, where we talk about right to peace, self-development, etc., which does not come in a first generation. And this first generation of human rights, civil and political, come into our fundamental rights. Second generation of rights, that is civil, economic, social, and cultural rights, comes into our directive principle of state policies. And apart from this, third generation, this word we talk about, we come in the form of case clause, in the form of PIL, where all the factors has been there. It talk about the legal aid, it talk about the environment, it talk about bonded labor, it talk about child labor, or other factors also where the Supreme Court, the apex, is the guardian of the Indian Constitution and the interpreter and the protector. If any public spirited citizen can file the PIL, where the concept of a not common man, but is a concept of a common people, so it should be filed before Supreme Court Article 32 and in 226 before the High Court. So this is a general concept of a human right from Western thought and the Indian thought. I have just covered it. So remaining part we will take on in a next class. Thank you very much.